Hi, this is video number 131, Foreclosure Defense, Kings, Queens, Bronx, Richmond, New York counties, the 5 boroughs, and other counties, Suffolk, Nassau, and Westchester. I'm Carl Pearson. I'm a New York attorney and a graduate of Harvard Law School. And I'm preparing this video for homeowners in the 5 boroughs and the surrounding counties to help them deal effectively with foreclosure actions brought against them. I've been defending foreclosure actions throughout New York State for many years, particularly in the counties of Kings, Queens, Bronx, Richmond, New York, Nassau, Suffolk, and Westchester, which I'll refer to as the 8 counties. I'm preparing this video to enable homeowners facing foreclosure in any of these 8 counties to understand the present status of foreclosure defense, including loan modifications, which is constantly changing, somewhat like a swinging pendulum. I'm going to make a series of important points which may not seem related to you, but they all play an important part in the foreclosure process, and you should know what these points are to give you the best opportunity to manage your foreclosure problem. 1. The 2 most important points that come to mind are, first, that you need to retain an experienced foreclosure defense attorney to represent you in the foreclosure action. Homeowners that fail to do this, presumably to save on the expense, are far more apt to lose their property to a foreclosure and sale, and do so more quickly as well. The cost of retaining an experienced foreclosure defense attorney is quite low in comparison to the costs to the homeowner in losing his or her home and being forced to start paying rent or mortgage payments perhaps 2 to 3 years earlier than might take place otherwise, and of course the related moving expense. Also, having a volunteer attorney fill out a form answer for you is almost the same in many or most instances as having you do this without such assistance, at least where the volunteer attorney fails to include any affirmative defenses. The answer without affirmative defenses in New York is inadequate to protect the homeowner in many or most instances, so beware. Please note, I have a plan to make my representation affordable for most homeowners, and please ask me about this plan. 2. The second of the 2 most important points is to file your answer with your affirmative defenses and any counterclaims on a timely basis, which for many homeowners is within 20 days after personal service of the summons and complaint. My recommendation is for homeowners not to try to determine whether they were lawfully served or not, because a judge might hold otherwise, in spite of what the homeowners may believe. The best course of action for most homeowners is to file their answer with affirmative defenses and any counterclaims on a timely basis and preserve their objections as to the propriety of the service, which objections usually become moot after passage of a few months. If you follow my first 2 points, you can probably remain in your property anywhere from 2 to 3 more years up to forever, depending upon many factors. But at least you most probably would have no immediate problem in being forced out of your home. 3. Your attorney needs information from you to make an initial assessment of whether, and if so, how you may remain in your home. These various things that may have to be done to get you ready to save your home, and you and your attorney need to review your fully disclosed financial status at the outset of your attorney-client relationship to enable you and the attorney to figure out the most suitable plan for you to save your home if possible, or to achieve other stated objectives such as remaining in your home as long as possible without paying the mortgage, to enable your children to complete high school, for example, or to avoid a deficiency judgment, or to take advantage of a perceived equity in the mortgage property, that is, a market value in excess of the liens against the property. 4. You probably will need the services of a highly experienced loan processor working with your attorney who is familiar with the current loan modification trends and is able to prosecute your application by knowing in advance whether it meets the requirements of the lender. And who knows how to cause trouble for lenders that fail to abide by the rules. My office has such a person, and most homeowners defending against foreclosure can reasonably expect to wind up working with a loan processor, no matter what objectives they may have. 5. Litigation is an important part of your defense, and litigation is permitted as a practical matter only until you have answered the complaint and the lender files any necessary reply to counterclaims. Your answer is the most important document you can file in the foreclosure action. Failure to file it on a timely basis prevents you from defending the action thereafter, and an ill-conceived answer is easy for the lender to overcome and represents almost no defense at all. A well-conceived answer, however, tells the lender in advance that if it's unable to grant the homeowner an affordable loan modification, there may be several years of time-consuming and costly litigation activity, including appeals as to the various issues raised in the answer, which often encourages a wise lender to bend over backwards in trying to come up with a loan modification agreement that will be acceptable, return the loan to performing status, and then end the foreclosure action and allow you, the homeowner, to remain in the home. 6. I want to note that there are differences to be taken into account when a homeowner doesn't live in the property and when the homeowner has given an interest in his or her property to someone in exchange for assistance in saving the home. For example, conveyancing under law of New York may be limited to only a single session, and the transfer of an interest in the property may prevent an acceptable loan modification offer from being made by the lender. 7. Times are changing in the foreclosure field. Judges have heard and dealt with most of the issues that are circulating on internet and have not rendered decisions saying that mortgage securitization is illegal. Instead, the judges generally try to give homeowners an opportunity to save their home through obtaining a loan modification agreement if the lender offers one. But if the lender does not, the judges generally go along with the lender's litigation efforts to obtain an order permitting foreclosure and sale of the property in absence of some serious litigation efforts by the homeowner's attorney. The litigation effort that is needed at this point, if the homeowner does not obtain a loan modification agreement, is often substantial, and if the effort is able to identify some still open legal issues that could block foreclosure, the judge may rule in the homeowner's favor, and this possibility may cause the bank to reconsider its earlier rejection of an affordable loan modification agreement. Skilled foreclosure defense is a necessity for many homeowners to keep their property, but other than for the answer, the litigation skills are used to create the litigation documents only if the lender refuses to give a loan modification agreement, or possibly if the lender is acting in bad faith during conferencing. 8. I now want to make the point which can be considered the third most important point, which is that in New York State, immediately after the answer is due, and whether or not the answer is actually or timely filed, or filed at all, the lender is required to put the foreclosure action into mediation before a referee, special court-appointed official, or sometimes the judge's law clerk, or the judge himself or herself, to try to see if the lender will grant an acceptable, meaning affordable, loan modification agreement to the homeowner to end the foreclosure action. This period is known as conferencing and is required under CPLR 3408. And in subparagraph F, there is a duty on the part of all parties and their counsel to negotiate in good faith. This is the only time with your bank dealings that the bank has to negotiate with you through your attorney in good faith. And it is my job to try to put together a case of bad faith negotiations if necessary, so that if you are denied a loan modification agreement, I can make a bad faith motion to bring the lender's bad faith to the attention of the judge, which often brings about an increased desire of the lender and its attorney to grant an affordable loan modification. As you can see from what I've said so far, there are a lot of things going on and to be considered, and the homeowner facing foreclosure needs to retain somebody who is aware of these things and knows what to do and knows how to do it. 9. Post-conferencing litigation has become far more important than in the recent past because the federal government programs that paid the major lenders and their services to offer affordable loan modifications is getting used up, and the major lenders and their servicers are using more litigation and less loan modifications as their strategy. In 2013, the government agency in charge of reviewing federal programs, it's SIGTARP, such as HAMP, reported that only 5% of the TARP monies remain for use by the banks when granting their loan modification agreements. Then you should know there are many lenders such as local savings banks, smaller banks, purchasers of defaulted mortgages for a quick turnover, meaning quick foreclosure and sale, sometimes referred to as vulture funds, which never had any government programs subsidizing loan modifications, or lenders such as vulture funds generally have no intention of creating a 30-year modified mortgage. They want a 3-month sale of your property, which takes extra litigation effort to oppose. So an important factor is who owns your note. And you must remember that note ownership can change overnight without your knowledge or permission. 10. You may have heard of MERS, M-E-R-S, or Mortgage Electronic Registration Systems, Inc., now known as MERS Corp. or MERS Corp Holdings, Inc. I'll refer to this organization as MERS. MERS was created by the Wall Street law firm specializing in securities markets and has succeeded in its efforts, and what few people know is that, among other things, it is an exchange for the purchase and sale of defaulted mortgage loans, with the mortgages being held in easily transferable street name, that is, in the name of MERS, comparable to what the securities market has for stock, where it's held in street name. The lender servicer members have access to the assignments of the note and mortgage, but you and I don't have such access, which means that the typical homeowner in New York or elsewhere in the United States has no way of finding out who really owns his or her signed note and mortgage. The note can be and often is sold without any filing in the office of the county clerk or registrar of deeds until a new owner decides to sue on the note and mortgage. Then this new holder of the note or its servicer executes an assignment in MERS name, files this last assignment, and by the way, it could also be in the name of the assignee, it's changing there, files this last assignment of mortgage with the clerk or registrar, pays any mortgage recording tax which prior assignments avoided, and then files its foreclosure action against the individuals on the deed, note, and mortgage, occupants of the property, junior lien holders, and others. It takes a knowledgeable foreclosure defense attorney to understand what is going on and how to best prepare a homeowner's defense. 11. An interesting issue I raise are several related federal and state antitrust violations which took me a few years to see, even though I have spent many years of my litigation lifetime in federal court as an antitrust litigation attorney representing small companies. I look for instances where the homeowner's client's rights have been violated and injured by such antitrust violations, and include the violations in my affirmative defenses and sometimes in my counterclaims. 12. I have pretty much said what I planned to say, except I wanted to end this video by telling you that you may want to start your efforts at saving your home right now, rather than waiting for a foreclosure action. The reason for this is simple. The more you owe in past due mortgage payments, the more difficult it is for the lender to grant a loan modification agreement, because a loan modification agreement, if it is not a so-called forbearance agreement, reduces your total debt either by lowering the interest rate and or by reducing the principal amount owed for the purpose of making the loan affordable, meaning, and they also eliminate the past unpaid mortgage payments, which is a loss to the bank that they take into account. So if you have very little in past due payments, the lender may be able to come up with an affordable monthly amount without having to give up too much in interest, principal, and prior unpaid payments. You need to take this observation into account when seeking delays, because delays may make it more difficult for the lender to grant an affordable loan modification agreement, especially when there is no or there is substantially less subsidizing government money to reimburse the lender. 13. I'm done. If you have any questions, please give me a call at 212-307-4444. That's 212-307-4444. I look forward to speaking with you and helping you to save your home.